All right. Well, I think now would be a good time to kick things off. So let me officially welcome everybody to our first of our winter webinar series. My name is Sarah Justice. I'm the Communications Director for the South Carolina Bar and the co-chair of the Professional Development Committee for NABI. And I know our PDC is very excited for this series. As we all know, AI is everywhere. It is taking over so many things, and we want to be ahead of the game. So we're very excited for this. If you haven't signed up for the full series, you still can. There are two more after this next week and the week after. So we are just delighted to have everybody here. And we want to be sure to thank our sponsors who are on the screen in front of you. They help us do what we do. So thank you very much to all of our sponsors, and especially today to the incomparable Mauricio Fonseca from Member Central, who will be introducing our speakers.
Yeah, thank you, Sarah. It's my pleasure to introduce Kiki L'Italien, a luminary in the association industry renowned for her transformative leadership and digital prowess. As Vice President of Marketing and Community Engagement at Big Red M, Kiki's 22 years of diverse experience fuel her dynamic strategies and community building initiatives. Notably, as editor-in-chief of Association Chat, Kiki cultivates a vibrant online community, hosts an engaging podcast, and delivers insightful blog content, solidifying her position as a leading voice in the industry. And joining Ms. Italian is Jeff Tenenbaum, a distinguished figure in the realm of nonprofit law. With the wealth of expertise as a managing partner of the esteemed Tenenbaum Law Group, Jeff's counsel navigates the intricate legal landscape facing nonprofit organizations. And renowned for his contributions, Jeff's accolades include the American Bar Association's Outstanding Nonprofit Lawyer of the Year award and recognition in the U.S. Legal 500's Not-for-Profit Hall of Fame, which clearly underscores his commitment to excellence in the field. And finally, I'd like to give a shout out to ChatGPT for assisting me in writing these introductions, in case you couldn't tell. I look forward to hearing more about the legal implications of using AI.
Right, Kiki and Jeff,
All right.
the floor is yours.
That's wonderful. And Jeff, if you need to interrupt me as I get started, we're talking about the maze and the marvels, and we're talking about the policy, and we're talking about the practical things that you have to be thinking about when you're looking at AI, when you're thinking about specifically about generative AI. And that is why I want to get started with in this conversation, because we want to make sure that we have time for Q&A and things like that. I want to get started in talking about basically like the three questions that I'm hearing most often now, right now. And if you're listening to this for some reason down the line, it's February 2024, so things are probably going to be completely different in like 6 months from now. But right now, it's really three main questions that I'm hearing from people. What is it? Should we? And how do we? Right. And I think that the what is it is kind of tricky, because by now people have heard of Chat GPT, maybe even played around with it a little bit. They have been seeing AI in the headlines everywhere, and a lot of scary things that are attention grabbing that have to do with plagiarism and things like that have been in the news. So it's impossible to escape hearing about it. But the answer keeps changing when we're talking about AI, because there's a lot of different types of artificial intelligence. Artificial intelligence has been with us in many different ways for a long time. It's incorporated into tools we use every day. It's part of spell check. So we're very familiar with AI, but then we're also seeing these large language models powering generative AI tools like ChatGPT, Bard, Claude, and all of the visual tools that we have as well. And then we also have something that we don't hear as much about that we're starting to hear more about it, which is we have AI agents, which are basically these little wonderful technology marvels that are going about and doing things on our behalf using AI, generative AI, and machine learning to kind of go about and do more complicated things with some of the tasks that we give them. And these little AI agents can go out and regularly go and sort of collect all of the little pieces of information and then produce the next step for us. So all of this starts with your data. All of this starts with looking at what's going to be the most valuable. And these tools really do look like magic. The one thing that we know for sure about AI is that it's not staff. It's not, these are not people. So I was in a conversation the other day with some other association podcasters, and one of them was commenting on somebody that I recently had on the association chat podcast, who, when they were training their association, they were talking about the different AI staff, employees that they had, and they named them so that they'd understand, sort of relate to what it was that they were doing and how they could help. And I thought it was really clever and it was creative, and it was a way to make this technology look less scary. But some of the other people, other podcasters were saying, yeah, I don't like calling it your AI staff, because I think that kind of makes it equal to the human employees that you have. It's probably a little bit scary when you see headlines about AI taking jobs, and then you're being introduced to the new staff members who might be the ones taking your jobs. So it's kind of an interesting time, because we're all trying to figure out how we feel about it, how we're talking about it, how we're relaying this information to staff. And so that feeds into this "what is it" question. We know that it allows you to be more efficient. We know that it allows you to customize at scale. So there's like all of these fantastic things you can do with it. But the main question that you're asking yourself at this point needs to be, how can we add value? First, do no harm. How can we add value? And really looking at how you can use these tools in new and innovative ways for your association to begin to add more value and more value to the people that you're engaging with. On the should we, it's about trust issues always. Should we do it? This ranges from philosophical to legal. And it's really like this idea of, should we go ahead and jump in? The legal, and Jeff will talk about it in a second. It'll be a great opportunity for him to jump in. But it's like, really, it's like these trust issues, competence and character. Can I trust that the people will use it the right way? If we use it, right? Can I trust that they're going to use it the right way? Do they have the competence to use it the right way and not share anything that's confidential or proprietary into something that could be accessed, right? And then it's also this character. Will they do it and use it the right way and not do something that is has to do with intentionally, I don't want to say, acting as a bad character, but something like that, right? The other thing is, can we trust its output or information that it's giving us? So there's still a lot of questions about trust in the tools themselves. And then there's also this whole philosophical and very real sort of existential crisis we're having about who are we as humans and where are we headed? And, is humanity doomed if singularity is reached? And we're not going to really talk about that today at all. But these are some of the questions that go into the should we. And finally, the how do we? We talk about policy. We talk about how do we go about creating a policy that is meaningful, that's going to be something that is effective, doesn't scare, it supports, but it covers you in a way where you feel safer in so many different ways. There's also this question about organized attention to future use, establishing some sort of task force so that your different people representing different lines of your business and in your organization are at the table actively thinking about, how do we use these tools and how do we think about our data in different ways so that we can begin to use this in an intelligent way as we're learning more about what the capabilities are. And then finally, I think in the how do we question, it's a lot of questions about how do we roll this out? How do we begin inviting staff members? How do we know when it's time to begin to invest in something like, should all the staff have Copilot, right? Should they be using that? Should we allow them to use? Should we encourage them to use some of these AI tools? So I'm going to take a breath because you don't want to hear me talking all the time. But those are basically, that's kind of the three buckets of questions that I've been hearing over and over again, and what they tend to trickle down into when you're thinking about what the questions end up really being about. Oh, Jeff, yeah.
Sorry. After my 2000th time of using Zoom last 3 years, 4 years, whatever it's been, I don't know how I still make that mistake once in a while. But anyway, that was great, Kiki. And I hope that you'll be able to get into some of the answers to those questions based on your extensive experience working with hundreds of associations and association executives on these issues. So I, of course, as a longtime 28-year association lawyer, I'm always asked about all of the newest, latest, hottest, hot button association legal issues. And over the past year, this has absolutely been one of them. It's a topic that I get asked to speak on quite regularly these days. It's a topic that I get asked by clients to advise them on. And like Kiki said at the top, it's ever evolving. From the technology to how associations are using it to policies being developed to regulate this, which are still very much a work in progress. So for instance, I think it's really, really important for every association to have an employee AI usage policy. Yet I have yet to see one that's really good. And I hope there are some out there, and we're asked to review them, and at some point we'll probably take a stab at doing our own kind of model template, although there really is no model. For some policies, it has to be tailored to the association. But there are a lot of legal risks. I posted in the chat an article of mine about that was written earlier April of last year. So even since then, a lot of things have evolved. But I highlighted kind of 5 key legal areas that associations should pay attention to in connection with generative AI usage. So take a look at that, and I'll be talking about some of those things today. Like in every area, AI is nothing specific to nonprofits and associations, but its use and how it's used, generative AI by associations, certainly creates a unique set of risks that are in some cases very similar to, say, for-profit companies that use generative AI, but in some cases they're different. For instance, because of the role of volunteers in connection with the running of associations, as volunteer leaders, as speakers, as authors, things like that. Some of the risks, like in all areas, are more significant. Some are lesser. And some of the risks, not all of them for sure, but some of the risks are going to be mitigated by certain features of the AI usage. So one thing I want to talk about first, then Kiki, I'll pass it back over to you, and then I'll dive into more detail on some of the specific legal areas. And like I always try to do, not just explaining the issues, but telling you some practical tips on how to mitigate your association's legal risk, your bar association's legal risk in that area. And I am far from a technology expert, not by no means, but one thing I have learned by reading up a lot on this subject is that like 2 of the largest, most commonly used generative AI platforms by associations are the 3 largest that I've seen from asking our clients and seeing things that we're reviewing are ChatGPT, Bard, and Claude, those 3. Now, Claude is unique from ChatGPT and Bard in that it tells every user that, subject to a few exceptions, it does not utilize user inputs to train its algorithm. So think of generative AI as inputs and outputs. At least I've heard this term used. I didn't make this up. Inputs are what you put into it. Outputs are what you get back from it. Could be a question as an input. It could be data that you're asking the platform to analyze. It could be, a whole bunch of text that you want it to synthesize or organize. Whatever the case may be, you got inputs and you have outputs. So Claude says it won't use your inputs to train its algorithms or to in any other way improve their business, their product, anything else. Not the case with ChatGPT and Bard. They do that. However, depending on which version you subscribe to and pay for, there apparently are features on both where you can turn off the ability of the platform to utilize your inputs to train their algorithms or to use it in any way. And so that ability to do that is really important because some of the risks, and you alluded to this, Kiki, a little bit earlier, come from, for instance, putting confidential or proprietary information, personally identifiable information, other things like that as an input into the system. Because if it's going to kind of go in and just go out to allow the platform to train their algorithms and possibly make its way into others' outputs, you put it in, it goes out into the ethosphere, and then it comes back and shows up on someone's computer screen someday. That's a real potential problem. Now, of course, regardless of whether you're using Claude or you're turning off that feature, or by the way, there are also kind of enterprise versions of these platforms, just like most associations that have more than one employee, have enterprise versions of things like Microsoft Office, where you pay for an enterprise subscription and then everyone up to a certain number of users can use it. You can do that with these platforms as well. And if you do that, for instance, and you ensure that your, enterprise version has that sharing mechanism, that training mechanism turned off, or you use Claude or whatever, then it's less of a concern, obviously. But then, of course, you have two things. One, you want to have an AI employee usage policy that says you can only use any generative AI platform in connection with your work if you're using our enterprise version. Because anyone could just go into their computer, go into their browser, go into whatever version of ChatGPT or Bard or whatever, and like people are doing it now because most associations have an enterprise platform. But you want to mandate that employees can only use the enterprise version if you have one. And then number two, you still want to have one of the requirements in your usage policy that you can never input any confidential or proprietary information, that sort of thing. I kind of view that as like a belt and suspenders approach. So while there are other legal issues that can and will still arise, irrespective of that aspect, I wanted to talk about that first because it's something that I think a lot of people are not aware of.
Yeah, I love that you started out with that because that piece of it, I think that it's easy to think, okay, so I know we can create this policy, and so the staff, they just need to be informed, and we have these rules, and that will be that. But I think you all know how how well our assumptions and expectations are met when we have a situation where we're assuming that people are going to do what we want them to do. It just doesn't happen that easily. And then when you add the complication of working with volunteers, volunteer leaders, people who are very busy, who are doing many other things, who they get involved. And if they have a tool that's going to have, they upload all of the people that are on, on the board, they upload notes that were taken that have to do with information, and they're wanting to sort it out. When you have ChatGPT and tools like this that are on your phone, and it's super, super easy to be doing and multitasking and moving fast, why wouldn't they do it? Why wouldn't they use it? And are we also training our volunteer leaders about these safe uses and how we're supposed to be using these tools? So there are a lot of different areas in which things can go wrong. It's also kind of wild to imagine that people are not going to use these tools. We know, I mean, back when social media was the new thing. Imagining that you were banning people from ever getting on it, any employees of being on it. I mean, they would just use their own personal devices. It wasn't something that was going to be avoided. So we know that with a tool that's so efficient, that makes people, that saves time, and will take something that could maybe take 3 hours before and bring it down to something that takes 3 minutes, people are going to use it. And the more that they understand how to use these tools, they're going to want to use them. So we have to be hyper aware of how they're using them and providing them with the tools that will both make them, enable them to be efficient, and empower them to do better at their jobs, but also keep them from exposing the organization to risks unnecessarily.
Yeah, it's a great comment, and yeah, you want if the use of generative AI by your staff can make them more efficient, can make them more effective, can develop higher level work product that can reduce the time from 3 hours to 1 hour. That's a great thing, right? We want our staff
Yeah.
to be more efficient. They can do more things. You can maybe make your, I mean, people don't want to hear this, but I don't necessarily think it's a bad thing if AI ends up eliminating certain jobs, because the jobs that are left are going to be more efficient, more effective, and you reallocate people, you retrain them in a new area, you do other things like that. You don't want employees to do very low level work that can be done more efficiently by AI. That being said, it has to be balanced, like Kiki said, with good ground rules. And like every policy, we work on, my colleagues and I at our firm work on policies for associations every day. You got to have the right policies and of course update them on a regular basis, especially in this area. Like an AI usage policy for your staff that's written today is probably going to be partially obsolete a year from now. So you got to constantly update it, but then you need to create good policies, update them regularly, distribute them regularly, and make sure everyone's reading them, and then enforce them. Their policy. If people aren't following the policy, just like any other rule in the workplace, you got to take disciplinary action against that person. And if they become a multiple offender, just like any other violation of your employment policies, they might be subject to termination at the end. And so it's really important. It's really important to do that.
Yeah, I mean, I completely agree. I think that when you're looking at these policies, making sure that you're really going through them, you're also making sure that as things change, that they get updated, right? And you're not just creating it and it's a one and done kind of deal, because as things develop, you may have reason to go in and really and update those. The thing I want to emphasize here is that because these tools are so effective, because you can create and layer and do so many things. And if you want to, we can talk in a little bit about some of the very first things you can do that are going to be helpful to your staff and things like that, to help streamline some of those tasks to make their jobs, more enjoyable. But the most important thing I think that you need to know coming out of this is, yes, be aware of the risks. Also take that and understand that if your data is gold, and for most associations and for most organizations right now, it really is. What do you do with gold? You protect it, right? You might look at it and figure out how to make it grow, how like reinvest it and like make it grow. But you need to protect what you have. And these tools are making it more effective for, the bad guys to basically be able to compromise systems. So this is when you need to be aware of what kind of data you have. You should already be doing this anyway because of things like GDPR and some of the rules where we're looking at, how we're protecting our members' data and information. But you also need to be aware of what your vendors' policies are and how they're using the data that they're accessing whenever you're working with them. A lot of technology vendors have this information, but you maybe haven't really gone into it as in depth as you need to. And if you have that gold that is your data, and there's opportunity to continue to develop more for your members to provide, better services, better benefits, to actually understand them a whole lot better, then you need to think about what are you doing to safeguard your system, because it's not just huge companies like MGM had this massive cybersecurity breach, and they're still dealing with the aftermath of that. But these tools make it a lot easier for these attacks to happen, ransoms to happen. So that's another thing you need to be thinking about, is as you're looking for opportunity, you really do need to think about how are we protecting ourselves from risk.
Kiki, can you get into some of the kind of more nuts and bolts, kind of practical ways that we lost Kiki? Okay, well, while we wait for Kiki to return, let me kind of move on and talk about some of the specific legal areas of risk that you need to be concerned about. And by the way, can someone just let me know if we're still live here or if there was another technical glitch? I'm only seeing,
Nope, you're good.
we're good? Okay.
Yeah.
All right. Just let me know when Kiki's back. But let me move on and let me talk about some of the specific legal areas of concern and most importantly, what you can do to mitigate those risks. So there's a number of areas. I touched on some of them in my article, but there's more. So let's start with, Kiki and I both mentioned making sure that your policy for employees prohibits employees from entering any confidential or proprietary data or information into the generative AI platform. That's really, really important to do. And then, of course, enforcing those rules. But sometimes with other things that you might input, like for instance, if you have copyrighted information and you put it into the platform, again, if you can turn off that, I'll just call it kind of the ability of the platform to use that information and share it, use it to train their algorithm, then you're going to minimize the use that your copyrighted information kind of gets out there and can be used by someone else, possibly infringing your copyright rights. So that's obviously very important to do. But at the same time, sometimes it is going to make sense to put some copyrighted information into the platform because you need the platform to do some sort of analysis. Well, one thing that we found and that others have recommended is that anytime you're putting any information that's subject to copyright protection, that doesn't mean that it's necessarily registered with the Copyright Office, but anything that either your staff created, which if it's within the scope of employment, automatically is owned by the employer, or if it's created by contractors subject to a copyright assignment provision in their contract, it's going to be owned by your association. And if it's done by volunteers, hopefully there's either a copyright assignment or license provision in some form or agreement that the volunteer signs, assigning or licensing the copyright over to your association. When you input that into the system, you want to be sure to use a copyright notice on that. The little C with a circle around it, the year of initial publication, and the name of your association. That's really important. It puts others on notice. And this is obviously a great habit to do with everything that you do. You're generally putting it on the front page, not necessarily every page of a document, but it puts others on notice that the information is subject to copyright protection. And if you later have to pursue a platform for some sort of infringement of your copyrights, it makes it much easier to track that down. Now, staying with kind of confidential and protected information, one question I've been getting a lot of, we're probably all seeing it, a lot of video calls that I'm on, I'm seeing, oh, another person has joined, the AI note taker has joined your call. And a lot of people are using this. Some are using it in connection with board meetings and committee meetings to essentially take notes. Just in the same way that some associations for years have done audio recordings of their board meetings for the purpose of the secretary or whatever person is in charge of creating meeting minutes to be able to have a record to pull from. Some have started in the last 4 years using video recordings. It's so easy to do if it's a video platform board meeting, recording the meeting. Really, really important issue here. I'm generally not a fan of it, but to the extent that anyone feels it's really important or necessary in order to have, good effective notes of a committee meeting or a board meeting or whatnot, or even just a call. But especially when it comes to those sorts of meetings, I've always advised for my whole career that I'm generally not a fan of doing that. Because unless that you can be sure that recording is destroyed as soon as the meeting minutes are prepared, that creates that's a whole, depending on the content discussed at the meeting, it creates a whole bundle of potential liability risks, from antitrust risk to so many other things. It's the same reason that we've always advised that meeting minutes should not be a whole long discussion of this person said this and this person said this and this person said this. The meeting minutes should just focus on, the board discussed XYZ, the board voted to adopt this resolution, the board voted to approve the annual budget. It should just be, and meeting minutes should never be that long or detailed. So many different liability risks that can come from that. So at the same time, if you're going to use one of these AI note takers, if you feel you have to do it, do not just take what spits out of that and, put a few things on it and call it your meeting minutes. That's just not, it's too dangerous. It's not going to work in terms of mitigating your liability risk. That's my recommendation when it comes to that. In terms of copyright on the reverse side, kind of the outputs, there have been a number of lawsuits, as I'm sure you've heard, from musicians and others who are claiming, and plenty of others, news outlets that are claiming that these AI platforms are infringing their copyrights in the way that they scrape all of this data and then use it. On your side, when you get an output, one thing to keep in mind is that if you want to get copyright protection, like registering something with the Copyright Office to maximize your protection, one of the requirements under the Copyright Act is that the work has to be a product of human creation. So something that comes just out of an AI platform is not the subject of human creation. So if you want to make it subject to copyright protection, you have to put enough into it, and you should be doing it for a variety of other reasons, which I'll talk about. But you need to create, everyone, well, not everyone, but so many people these days, including me, will use it as a starting point to get some ideas, to get out of a brain fog, to spark ideas. I do it when I'm writing new articles, just to get ideas. And it sometimes is the most basic framework of where I might start, but it's certainly not where it ends up. And that's how everything that comes out, any output that you're using, you want to make sure that you're making it a subject of your own human creation so that it is subject to copyright protection. One thing you might not be aware of is that all of the AI platforms, if you read through all of the terms of use, terms and conditions, I'm sure all of you have done before you click that you accepted them. One of the things that's buried in there is that if the platform gets sued for anything, including copyright infringement, because of something you inputted in there, you actually have to indemnify them. You have to pay their legal fees, pay any judgments or settlements against them if it turns out to be the result of what you put in there. And so it's another good reason to make sure you have and enforce and distribute a good employee usage policy that regulates staff behavior in this regard. Why don't I stop there and turn it back to you, Kiki? And then I'll continue. I have a few more areas of liability risk. And actually, I lied. I'm going to talk about one more because it's kind of related to this. So similarly, any output that you get from the platform, I talked about copyright issues there, but another area that's really important is called tort liability. Most of you who are not lawyers don't know what that means. Anyone who is a lawyer knows it because it's one of the classes that every law student takes in their first year of law school. And tort liability is liability that arises from someone who causes an injury, basically. And one of the areas that's always been a source of potential liability, tort liability for association, has been when associations, which so many trade and professional associations, put out standards, or they have a certification or accreditation program, which is rooted in standards, or they have clinical practice guidelines in the medical space, or patient guidelines, other things like this. Anytime that an association is saying, this is what we expect in the industry or the profession, or this is what, how we believe that things should be done, or these should be minimum requirements that you need to meet in XYZ, whether they're voluntary or mandatory. If you are putting that stuff out there, and so many associations do, someone relies on that, an individual, a company, and it ends up causing harm to someone, physical harm, economic harm, psychological harm, any kind of harm. If it's deemed that your association was negligent in the guidance that it put out there, in the standards and the practice guidelines, whatever it might be, then you can be held liable for being negligent and putting out negligent guidance, standards, et cetera. And so if you are relying on AI to help you develop these standards, could be staff, it could be a standard setting committee of volunteers that's working on this stuff. And I don't think it's a stretch in the imagination to think that any association that's working on these things, constantly updating, revising them, is sometimes going to use AI. You need to be sure that everyone who's working on that document, on those standards or guidelines, is doing all of the necessary due diligence to not just rely on what comes out of it from the platform's output, to make sure that you're not being negligent in what you put out there. So now I'm going to stop, Kiki, and turn it back over to you.
That's okay. I was really, I think I angered our robot overlords, and my laptop just blew up. So I don't know what happened, but I'm back. Yay, technology. And I think that, I think along with the risk, so you always have to balance all of this with what's happening, where do the risks lie, and what are people most likely going to do? That understanding that human behavior piece of things is really, really critical. And that's why you're going to hear Jeff talk about it, and you're going to hear me talk about it, this need for training, this need for regular communication, this need to have ongoing learning happening internal in your organizations, so that you are watching and have a handle on things as they develop. If you don't have a task force, first start with your policy, right? Then make sure you have some sort of task force, a group of people who are actively looking at the ways that AI and your data can work together for your organization, and be aware of where the dangers are. Where I see already there being problems, and I mentioned before that, you know, with volunteers, you have a lot of volunteer leader issues where they don't get that regular training, they don't get that regular communication, and a lot of them, you know, they might be amazing people, but when they're trying to fit in their activity with your organization, they're going to be probably trying to do it and fitting it into their day rather than making that the priority. And that means that they could get fast and loose with some of the tools and not be asking some of the questions or following some of the protocols. And that's a danger, right? So we need to make sure that we're actively communicating with them. One of the other things I see, very excited staff people getting very excited about the fact that you can take a conversation that comes from people who are in chat rooms and things like that in some of these meetings, like what Jeff was talking about, and then inputting that into something like ChatGPT, not at an enterprise level, as something where they're playing with that information, a lot of which is probably confidential at some point, that they shouldn't be sharing, and looking for themes and looking for ideas. And it's, the thing is that a lot of these tools offer, it's like, you know, it's like this sort of treat, tantalizing treat that's out there for what you can do with it, because it really is amazing. But if you have access to, you know, your members' data, your membership database, and lots of information, personal information about your members, you need to be aware of not, you know, making any of that become available out to people that shouldn't have access to it, including how you're using these tools within your staff. Another thing that—
Can I interrupt you to give an example on that? So I was at a board meeting this week. Obviously, I'm not going to say the name of the association, but it's a board meeting where it's the CEOs of all of the member companies, and it's a pretty concentrated industry. So the you know, all of the heavy hitters are there. And I was there, as I always am, to monitor the meeting for antitrust compliance purposes. Board goes into executive session, and I'm there, and someone starts talking about some potential changes to the bylaws to create a new category of members. And then some people are talking about, well, but do we want to admit this kind of company into membership or this kind of company into membership? And someone says, oh, don't worry, we'll be able to vote, so we can decide who we want to let in, who we want to let out. I'm not going to bore you with the whole antitrust analysis of group boycotts, but bottom line, that was a very problematic discussion. And one of the reasons I was there is to explain, no, we can't do it like that. Membership standards have to be objective and clear, and they have to be enforced on an objective and consistent basis to avoid liability for group boycotts under the antitrust laws. If that meeting was being recorded, and there's a chance that you know, that AI recording, or, you know, a transcript or whatever, notes, and it makes it in there, and if it's not deleted, that's you know, a smoking gun for you know, an antitrust regulator or a plaintiff's attorney that wants to bring a suit in that area. I'm not saying that they would be successful just because of a discussion, but it's a problematic discussion that you don't want a record of. And if you're doing your own traditional human note, you know, meeting minutes, it's not going to show up in the meeting minutes. So just something to keep in mind in terms of those risks. Sorry, Kiki.
That's okay. And you know, if you begin to have questions on any of these points that Jeff and I are talking about, please type them into the chat so we'll know we can address them within the time that we have left. One of the things that I wanted to talk about that I said, you know, I get a lot of questions about is the how do we. So when people are looking at rolling things out, some of the easier and the less problematic ways that you can incorporate some of these tools and still use them is in repetitive tasks that are not using proprietary or confidential information, but things that your staff, might be doing every day, or things that you might be doing every day, that are repetitive in nature, that kind of have a formula. These are the types of things, if you write all of these tasks down and then figure out, what do I not like to do that's repetitive and that is sort of formulaic, perfect ways to experiment, to go and create some tasks around that you can then use some of these tools with, that are relatively safe. And I have some examples of those that I can share. There's a link that I'm going to send that is to an ebook that has to do with using ChatGPT for associations. And essentially, when you're doing these things, they're safe ways to save time, safe ways to get good information that's not going to get you into trouble. Understanding the value of these tools is really critical, because while we're trying to build up these policies and we're trying to put all of these things in place, it's important to not just sort of set it and forget it. And we talked about it before. Once you've already created this policy, you might want to go back and update it. Right now, I'll tell you what I'm seeing. I'm seeing a lot of, and Jeff was saying, I haven't seen a really good one yet. Me too. I'm looking. And people are sharing.
Please send me with the first good one that you found, Keith.
Right. Likewise, you send me what you think is good too. There's a lot being shared, and that's what you do at the beginning of things, right? Is that we share in this community, association community. People are sharing what they're creating. And hey, I would like to believe that if we chip away at it and keep going, that it's going to get better and better. But this is one of those reasons that I'm saying you need to have a policy, you need to have guidance. You definitely don't want your employees to just play fast and loose with your membership information, or any kind of information that's in there that could put you at risk. However, you don't want to just create this policy as a guideline and then leave it alone, because there are ways that we can improve these. There just really isn't the perfect standard out there right now.
Yeah. If it's okay, I'm going to pivot and talk about another area of legal risk. Another area that I and my colleagues do a lot of work is employment law, and dealing with potential employment discrimination and so many other issues in the employment law area. A number of large employers, I don't think it's a common practice yet in associations, but I wouldn't be surprised if it becomes one at some point down the road. But I've read about a lot of large for-profit companies that are using AI in the hiring process. Using it, as we all know, even our 7-person law firm, when I post, the last time I posted an ad for a new attorney, get flooded with resumes, and associations are no different. You get flooded with so many resumes. So wouldn't it be nice to have like an AI tool to screen those resumes, kind of tell it what you're really looking for, to make your lives a lot easier? We don't have to go through and read every one of those hundreds of resumes and figure out, which ones are going to make the cut. Let's just let AI do the initial sorting, and then we'll take, the top 20 that the AI platform says are meet the qualifications the most, and then we'll go to those. And then some large employers are doing that, and then they're also, say they narrow it down to their top 10 candidates. They have all of those candidates do a recording where they have to record themselves answering 10 different questions, and then those recordings get sent to the prospective employer, and then they have an AI platform analyze those recordings to see again which ones think are most qualified for the position. Well, it sounds great, sounds efficient, sounds like a great idea, right? But the problem is that these AI platforms, by definition, have built-in biases, because they are based on information that's out there on the web and so many other places that has kind of inherent bias built into it. And so if those biases that are built into the AI platform are being used to analyze the employment information, resumes, or recorded interviews, then there's a very good chance that the output may be biased. And that could lead to claims of employment discrimination. And there already have been some lawsuits filed by would-be employees of large companies to say that they were discriminated against because they have a very thick accent and or speech impediment, and the platform was not able to really understand what they were saying. So they got discriminated against because they didn't make the cut from the recorded interviews or things like that. And so if you are going to use AI in any part of the hiring process, you need to be sure that that's counterbalanced with the human element to make sure you're doing all of the human due diligence to root out that bias and make sure it doesn't make its way into the hiring process. Back to you, Kiki.
I hope that didn't mess things up too much as my computer came alive again. And so,
Oh, good.
yeah, so, I think that the other thing that what you made me think about is this use of ChatGPT for doing this screening as you're talking about the different types of things that you're doing with potential employees as you're going through with the interviews. Something I've been hearing about that is making me a little nervous, and I'd be curious about what you think about this, Jeff, is speakers and content providers for your education. These are things where we already oftentimes will make sure in the speaker agreements that someone's not using information or sharing images that are copyrighted, that they don't have permission to use. This becomes more of an issue when people are sharing information and we're asking for our tools to go through and pull that information for us, a lot of times not going through and making sure that what it's filling in the blanks with is actually something that we have permission to use. And not also talking with your content providers and making sure that they've approved their materials to be used this way. And I think that it's really important to think about this because I'm beginning to hear in the speaker community, professional speakers, for many years, one of the issues was like, you can't record somebody and then share that and distribute it without informing them and getting their permission ahead of time. Well, now they're saying, well, what are you going to do with my data and my information if I share it in the room? At the same time, they're really concerned about how their data is going to be used. Again, proprietary information that you might have permission, you might have hired them to say it in that room. But and maybe they agreed to even have it recorded. But what you do with it after that, using these AI tools, you need to make sure that they're agreeing to some of that before you run it through and process it and provide it in different sorts of ways.
Yeah, it's a great point. And this is something that I've been counseling associations on for 28 years. And that is that the way that you deal with those issues is through a speaker agreement, an author agreement. So this goes for both speakers, and these are often volunteers, and obviously sometimes for paid speakers. Associations use both. And authors, who are sometimes going to be volunteers and sometimes going to be, freelance writers that you're hiring or consultants that you're hiring to write certain things for you. In all of these, there needs to be a written agreement. I'm not talking about a 10-page single-space contract. And especially for volunteer speakers and authors, I'm generally talking about a 2 or 2.5, 3-page document at most. We can get away with the essentials in 2. But there are a number of key things that have to be in there. Some of them, like you said, are representation and warranty, meaning I, speaker, or I, author, represent to you, ABC Bar Association, that this is my own original work, that if I've used others' works, I either got an assignment or a license, permission to use it, that the material does not infringe anyone else's copyrights, it doesn't invade anyone's privacy, it doesn't defame anyone, it doesn't infringe anyone's trademarks, things like this. Those reps and warranties are really important. You also, I am suggesting, when we've been writing in, addition to that list, something that says that if I've used AI at all, generative AI, in the creation of this content, that, I've done all of my due diligence to make sure it's my work product in the end. I'm not just relying on AI content. There are some, we have a lot of professional associations that publish journals, medical journals, academic journals, things like that. And some of them are making their journal authors disclose if they've used generative AI in the creation of the article. To me, I think it's unrealistic to say no, authors, speakers, you can't use AI at all to prepare your works. To me, that's just like back in the day when I started practicing, and some associations were having policies you couldn't use social media at work. Like that
Right.
just doesn't fly. It's not going to work. But making sure that the authors and speakers are representing and warranting that it is their own original work at the end. Like if a consultant is being paid to pull together, reports and analyze data and things like that, they might utilize AI to help them do that. But you want to make sure in the end that they've done all of their due diligence to make sure it's their own work. And the reason it's important for the association is that if you put it out there, and then you as the association, the publisher, the conference organizer, this happens all the time, you get sued for contributory copyright infringement or defamation or tortious interference or trademark infringement, invasion of privacy claims, you name it. If you can go back and point to the rep and warranty from the speaker, that's going to help you, the association, avoid liability for things like contributory copyright infringement. And also, if it's like a paid contract or consultant or something like that, you're also going to have an indemnification provision in the contract that says if you, association, get sued because of my work product, I agree that I'll step in, I'll protect you, I'll pay your legal fees, I'll pay any judgments or settlements against you. So I think it's really important. There's, by the way, a lot of other important things to put in those, including the right of privacy release that says, I agree that you can record me, you can use my PowerPoint presentation, you can use my article in any way that you want in the future without having to get permission, without paying me royalties, things like that. That's separate from copyright. That's called the right of privacy. But you want to build into those forms that release on the right of privacy so that you can use that in any way that you want.
By the way, you have my permission to use any of this today. Like if you want to, I absolutely, in perpetuity.
And actually, it's a good point. I don't remember if we signed, I think we did. I think we had to sign some kind of, or click and accept some sort of form as
Mhm.
speakers that hopefully, I think you go by Nabby, that all of those things are built in there. If you want me to review it, I'd be happy to. No, but it's really important. I've stressed this so many times for so long. It's really important that you do this with your speakers, with your authors. You build it into those forms, into your contracts with consultants, with vendors, and everywhere else.
Yeah, she says, you both signed a release form. It's good. We're good. And we both like promotion, so it's totally fine. Use it, use it, use it. I know that we just have about 5 minutes left, right? And so if you have questions, like I said, let us know. But I just want to touch on this idea that anytime you have these agreements, any place where you're asking for people to agree to share or some exchange, and I mean, look at your consultant agreements, look at anytime you have somebody that's coming in who's accessing your data and working with that. There are a lot of really fantastic consultants that are out there doing great work. A lot of them may not be up to speed on ways that you should and shouldn't use these tools. Everyone's kind of learning at the same time. So again, these discussions that you have with your tech providers, with anyone who's accessing this proprietary information, what happens if you're working with a consultant who is working on your strategic plan and is collecting all of this information and doing these interviews with stakeholders? It's something that we regularly do when we're going through and collecting information. It probably curdles Jeff's blood to think about what is happening when these consultants could then go and upload your organization's information, these notes, these interviews, and run it through something that's not an enterprise protected level version of, say, ChatGPT.
Yeah, it's a great point. So if you're hiring a consultant to take your data, your information, and analyze it, you might actually say you are not allowed to run this through an AI platform, or you can only run it through Claude, or something where it's not going to be later potentially get out there and shared.
Right. Yeah, I think it's important to have your bases covered and to at least broach the topic, because I think of human behavior. I think what we've seen, people are going to do the easiest thing the most often that they can, and so we have to protect ourselves, and we have to think, okay, if that's the case, bring it up in conversation and make sure that the people you're hiring understand that you're working with people that are paying attention to how your data is used. And so with that, I guess, you know, we don't want this to be like an AI discussion where it's just scary, 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 or that it's all glowing and like, please go and do everything you want to try. These are excellent, amazing tools. The technology it's so valuable for you to be able to look at, explore, and make things better for your staff, for their lives, for your life, for the benefits that you provide to your members. But you just want to do it in an intelligent and careful way and thoughtful way so that you're, you know, taking the trust that your members place in you and you're doing the right thing with it.
Very well said. And let me add to close us out that, and I gave you a lot of practical tips about steps you could take to mitigate your liability risks in a number of different areas, from IP to confidentiality, data privacy, tort liability, employment. And I strongly recommend that you implement all of those steps to the greatest extent possible. But like everything else, you need a safety net. Things are going to slip through the cracks. Things, you're going to get sued. Or you're going to have a regulatory enforcement action by a federal or state agency. It happens all the time. I know, because I'm in the middle of these things. That's where insurance is so important. Insurance is your safety net. Now, you can't insure against everything. For instance, breach of contract, except for employment contracts, you cannot get insurance for. But you can cover most of your legal risks in most circumstances through insurance. And so there is no one insurance policy that covers all of these risks. I'd say the two policies that are most relevant in terms of the kinds of risks we've been talking about here today, well, three. One is cyber insurance, which every association needs to have, especially when it comes to data privacy issues and breaches and malware and hacks and everything else. Second is directors and officers liability insurance, which the name is a misnomer. Yes, it covers directors and officers, but it also covers employees. It generally covers committee members and volunteers, and it covers the association itself. And those are the claims that are typically get filed with the insurance carrier, or claims against the association itself. Employment claims being by far the number one category, and a number of other things like copyright infringement, trademark infringement, defamation, etc. But then there are a lot, and most policies will cover, maybe with a sublimit, antitrust claims as well. But then there are certain types of activities. If your association does a ton of publishing, if you have a certification or accreditation or standard setting program, where you put out practice guidelines in a profession, those things are generally going to be excluded from coverage in a D&O policy. And that's when you want to go out and secure an errors and omissions policy, sometimes called a media liability insurance policy, which can cover those additional types of claims. And then finally, a lot of associations have kind of an umbrella policy over the top that kind of provides excess coverage beyond the limits of liability in those underlying policies for any claim or suit that might go above that. So insurance is a really important safety net. Don't overlook it. And it's the top of the hour. And I'll back over to you, Sarah. But Kiki, thanks so much for a terrific discussion. I learned a lot from you and really enjoyed it.
I learned a lot from you. That's so kind.
Man, thank y'all so much. That y'all gave us so much to think about. I am thoroughly terrified, but that was incredible. Like, we really appreciate both of you speaking to us today. So thank you, thank you, thank you. And with that, look forward to seeing everybody next week for part 2 of our AI series, where we will be digging a little deeper into actually how to use the various AI platforms. Now that we all know the risks and can go into it with a little more thought. So thank you both again. We appreciate it. And we will see everybody next week.
Thanks. Take care.